there, my name is Rodrigo de Azevedo Martins, and I am a criminal lawyer based in São Paulo, Brazil. And today I want to speak with you about a subject that I consider both important and necessary in order to better comprehend the Brazilian criminal justice system. I want to thank Chambers in the first place for the opportunity and the space that was given. And so let's start. The subject that I want to talk with you, to discuss with you, to speak with you is what I believe to be a subversion of Brazilian criminal law. Criminal law in general should be a subsidiary instrument of protection of fundamental legal goods. This protection is said to be subsidiary because criminal law must be the ultima ratio. That is the last resource available to the democratic state under the rule of law to deal with social conflicts. And that is, as explained by Winfried Hassemer, for example, because the most intense instruments of deviance control, such as coercion, use of force, deprivation of liberty, are at criminal law's disposal. And therefore, it should only be responsible to deal with the worst conflicts between individuals. Also, it is important to say that criminal law should only punish conducts, for it would cease to be a legitimate instrument if individuals were punished for what they are, not for what they did. So once a certain conduct is criminalized, not only the state symbolically affirms that it causes, or at least risks causing, serious harm to the social order, but also communicates that there is not a less rigorous instrument other than the criminal penalty to deal with this specific social conflict, that is crime. In Brazil, our penal code states that the criminal penalty should be set by the judge as sufficient and necessary to both prevent and reprove the crime. Regarding tax evasion, and that is where it starts getting interesting, Articles 1 and 2 of Law number 8137 of the year 1990 criminalize an extensive list of conducts, such as deliberately underreporting or omitting income, claiming false or overstated deductions on a return, or hiding or transferring assets or income. The criminal penalties vary between 2 and 5 years of detention to the conducts listed in Article 1 and 6 months to 2 years to those listed in Article 2. However, if the defendant carries out the payment of the full amount of the tax debt and its accessories, which is a fine that can exceed 200% of the tax evaded, plus huge interest rates, plus monetary correction, at any time, even after the criminal conviction is final and unappealable, the crime is extinguished. Additionally, if the defendant agrees to pay the total amount of the tax debt and its accessories, installments, before the public prosecutor's charge is analyzed by the judge, the criminal procedure is suspended until the payment is carried out. When it does, the crime is also extinguished. The situation described is problematic. Once the aforementioned list of conducts of tax evasion is criminalized, the state symbolically affirms that no other instrument but the criminal law is sufficient to deal with the seriousness of the matter. Moreover, we must also have in mind that criminal penalties are intended for those who practice such conducts. And the Penal Code states, Brazilian Penal Code in that case, that the judge should set them as necessary and sufficient to both prevent and reprove the crime, again indicating that criminal repression would be imperative in those cases of tax evasion. The question that arises is, if the payment of the tax evaded plus its accessories is enough to extinguish the crime, Why was that list of conducts criminalized in the first place? Wouldn't the tax enforcement procedures be enough, for example, considering that even the minimal criminal penalty is not applicable after payment? The criminal law, consequently, once a subsidiary instrument of protection of fundamental legal goods, as we said in the beginning, is subverted into an instrument of intimidation with an eminent purpose of raising tax revenue. In other words, it becomes a mechanism of threatening individuals to pay their tax debts, since the criminal conduct of tax evasion itself seems to become irrelevant once the money is collected. To reinforce this argument, let's imagine that an individual steals a cell phone from a large department store here in Brazil. Feeling repentant a couple of days after, he decided to return it before the public prosecutor's charge is even analyzed by the judge. In that case, Brazilian Penal Code states that there will be a reduction from 1 to 2 thirds of the criminal penalty imposed, not the extinction of the crime. The price of the cell phone and the fact that it was returned, thus, are only relevant to guide the intensity of the criminal penalty, because it is on the act of stealing that lies the true reason for the use of the criminal justice system. On the contrary, in tax evasion crimes, the conduct described in law merely authorizes the state to use criminal proceedings to threat individuals so that the amount due can be collected. It is possible, therefore, to state that the criminal law does not intend to punish the act of evading taxes, but to punish the tax evader who will not pay his tax debt under the specified conditions. The act of stealing, from the state's point of view, would be more harmful than the act of evading taxes, as can be seen. Even though it is quite rare that somebody steals something, which value is comparable to substantial tax evasions. There are, I believe, several ways to try to explain it. It could be said that there is a utilitarian reason for extinguishing the crime of the person who fully pays the tax evaded, since it would be better to incorporate the money evaded into the treasury than to punish the individual with the criminal penalty and not having the amount collected. On the other hand, it is also possible to say that criminal law works in different ways depending on the public that it is aimed at, as denounced by Eugenio Raul Zaffaroni, among many others. In a third world country such as Brazil, the crime of stealing is usually committed by the most vulnerable part of the population, whilst the big tax evasions are obviously committed by the wealthiest part of it. While the most vulnerable part of the population will be offered a reduction on criminal penalties if they return the stolen objects, the wealthiest part of it will have their crimes extinguished by returning the tax evaded plus its accessories. I believe it is perfectly possible that both justifications are correct, such as the utilitarian one and the criminal selectivity one, just as it is perfectly possible to raise other answers. However, it is important to highlight and conclude that the criminalization of tax evasion in Brazil, especially those aforementioned conducts, at very least seems to escape the logic that legitimizes the criminal law as an ultima ratio instrument aimed at punishing conducts. In first place, it is used to raise tax revenue and not for subsidiarily protect fundamental legal goods. In other words, what is intended is not the criminal punishment of evading taxes to reprove and prevent it, but to threat individuals via criminal procedure so that their tax debt is paid. In second place, it is not true that all the conducts of tax evasion are considered as criminal by the Brazilian state. Only those practiced by individuals who are not able to afford the payment of the tax debt, or by those individuals who are not willing to pay. Well, those are the reflections that I wanted to share with you, and I thank you all for the attention. I want to thank Chambers once again for the opportunity to connect with colleagues from all over the world, and also for the space given. And hopefully we can discuss this matter in another opportunity. Thank you all once again, and goodbye.